A lot happened over the last week, and this morning we're taking a closer look at the legal cases involving both Daniel Penny and former President Donald Trump. Again, several court cases happening both here and in Miami, and a lot to look ahead to.
Starting first with Daniel Penny, a grand jury indicted the 24-year-old man accused in the chokehold killing of Jordan Neely on a subway train in Manhattan last month.
And Neely was homeless. He suffered from mental illness, and he frequently performed in the subway system as a Michael Jackson impersonator.
Neely died after Penny placed him in a chokehold for several minutes on board an F train on the afternoon of May the 1st. His death was ruled a homicide by the medical examiner.
And right now, Penny is out on bail, and we want to break down more of what we can see next in this case. Legal expert Duane St, a former assistant DA with the Manhattan DA's office, joining us now for a discussion on all of that. So thanks for being here. Obviously, Penny has pleaded not guilty to all of it. Let's just start with what happens next.
So after the grand jury proceeding, ultimately, Mr. Penny is going to be arraigned in front of a judge. Obviously, there he's going to plead not guilty. The judge will ultimately get the grand jury minutes, review that, there'll be discovery, and the case will proceed, and very likely, as we expect, to a trial, because no one thinks that Mr. Penny is just going to accept responsibility or guilt for what occurred.
And Jeremy, there's been so much publicity surrounding this case, a lot of media coverage. Assuming it goes to trial, can Penny get a fair trial here in the city? Is that something that his defense will raise?
I don't think it's an issue of fair trial. I think that's what he can get. I think this will be a jury of his peers. It's not political in the sense of what we see, and we'll discuss later with Donald Trump, but there certainly will be a lot of emotion. The biggest piece here, in my opinion, I think most legal analysts would likely agree, is whether or not, if in fact this is manslaughter in the second degree, that he was so reckless and he was aware of this risk and he consciously ignored it that resulted in the death of Mr. Neely, pardon me. Not that it was intentional, but at the same time, was he legally justified in his actions and his response in the moment?
It seems like some people do believe that he was justified. In fact, he has raised a lot of money from people believing that this was in self-defense. So let's talk about what kind of battle that will be for the prosecution. I mean, listen, just here today on our air, we're talking about several incidents of violence on the subway. So how difficult is that going to be for them?
Well, there's always going to be that in the background, but what really the prosecutors need to do is really focus on the court proceeding, in this particular case, not what it may have happened on another train on another day or how it may have happened to you. They're going to ask some of these questions during jury selection. But what ultimately has to be proved, and I keep on using the term ultimately, is that burden is proof beyond a reasonable doubt that not only was Mr. Penny acting in that way I described before, but that there was not an imminent threat of danger to the degree and proportionately that required this not just serious physical injury response, but this response that resulted in death. Not that Mr. Neely may not have been aggressive or may not have been frightening people, but did it raise to that level? That's going to be the issue. Can you get a fair trial? Yes, but they're going to have a hard time going through all of these issues.
And Jared, finally, before we move on to Trump, obviously the video in this case is a big piece of evidence. Talk to us about the importance of some of the witnesses and the testimony from some of those other witnesses who are on board that train to kind of fill in the blanks from what we did not see, from what happened before the video was taken.
Yeah, great, Rocco. That's a great point because it's just that video in a small portion of time. What happened preceding that? And that's so critical to hear from those witnesses. Did Mr. Penny respond and act as a reasonable person in interpreting and reacting to this situation? So there's multiple people on that subway who are going to tell their story about what they saw, how everybody reacted, what that level of imminent danger was to anybody, if at all. So that is so important to whether or not the prosecution can prove this case beyond a reasonable doubt.
Let's move on to Trump now. A lot going on in that world as well. Of course, we have the hush money case that happened here in New York. There were all eyes on Miami during the week because of those federal charges about mishandling classified documents. Because that case involves these classified documents, let's talk about what kind of unique challenges that presents at a trial.
Right. When you think of a general trial, you think of maybe something being put up on a screen and everyone getting to see the everyone being able to see the evidence, even in the audience, not just the jury. Here, it's going to be a little different because there is top secret evidence. Now, that being said, the government as well as the community, the government has taken that information and very likely coded it so that ultimately the jury can listen to it, the judge can see it. But you, as the member of the public, are not going to know that, for example, this particular country or this particular person is named. It could be a letter like person A, country B. So they're going to take a really hard look at making sure It's presented so they can prove their case beyond a reasonable doubt. But at the same time, it's presented in a way that does not jeopardize that same information you're trying to protect.
And Jeremy, Trump has made a lot of comments about the classified documents. He has said that he had the authority to obtain them, to have them in his possession. He even declassified them when he really didn't. So how complicated would that be for his defense, since he has spoken so much, as Trump tends to do quite a bit?
He is his own worst enemy, and the Presidential Records Act does not say you get to just declassify because you want to. It just doesn't work that way. But what I think is also lost on a lot of people, and will be a very difficult task for the defense, is even if they can corroborate and establish and challenge that prosecution's burden that they have not met, that those records in question were not top secret, they had no impact on the nation and the defense of our nation, there is a grand jury process. And when that process includes a subpoena, you have every right to challenge that subpoena. But what you don't have the ability to do, and I'll use that term generally, is obstruct. And by obstruct, I mean you can't just say, I'm not going to comply. I'm going to move things around. I'm going to destroy things. I'm going to hide things. It doesn't work that way. So even if it turns out that it wasn't top secret, as we keep on saying those terms, there is still that major obstruction on his shoulders.
Good point, good point.
In addition to these two indictments, we have other investigations going on, so we will surely keep you busy. Jeremy Saland, good to see you. Thank you.
Thank you.
You as well. Thank you.